Friends, now we are dealing with the professional misconduct and other misconduct of an advocate. So, particularly Supreme Court advocate and other advocate, we also discuss this aspect. If we go to the Article 4 of the Supreme Court rules 2013, the responsibilities of AOR, we know that advocate on record is having special responsibilities in Supreme Court. Advocate on record is having special responsibilities in Supreme Court stipulated under Article 4 of the rules. So, what is the content? Special responsibilities of AOR have been stipulated where in Order 4. Order 4 of Rules 13. Okay, that is one. The next point is many of the provisions of Rule 4, of the Order 4 of the rules, many of the provisions of Order 4 of the rules are similar to the duties incorporated in the BCI rules. So, here BCI rules applicable to all other advocates other than AORs. So, BCI rules are there stipulating responsibilities of the advocates. So, advocates means other than AORs of Supreme Court. So, BCI rules are similar to rules provisions of Order 4 of Supreme Court rules. That is one aspect. So, we have to understand that rules of AOR or responsibilities of AOR incorporated in Rules 13. Other advocates' responsibilities are incorporated in BCI rules. Next. Thing is that apart from rules prescribed in BCI, various additional responsibilities cast on AORs under the rules. Various additional responsibilities cast. When we compare with these rules and those rules, we can understand that additional rules are there. So, that is one. Next, we are confining today the topic of misconduct. Misconduct, two types, professional and other. Professional misconduct and other misconduct. What are the precedents? We see the precedents in relation to professional misconduct of advocates in general as well as AORs. We have to examine thoroughly. Okay, come to precedents. After precedents. Violating the confidence, there are several categories. We are dealing the misconduct of the advocate under various categories: A, B, C, D, E, F, G, H, like that. So what are those categories? The first category is violating the confidence of the client. That is first. Violating the confidence of the client. For that, 79 judgment is there. 1979 judgment. V.S. Rangadurai versus D. Gopalan. What is the ratio? The client paid court fees and expenses to the AOR for the purpose of filing of two cases. However, only one case he filed. AOR filed only one case and falsely informed the client that the second case has also been filed. That is the wrong. So, false dates to the client. So, he also conveyed false dates to the client. Then Supreme Court held it is a case of professional misconduct. So, V.S. Rangadurai case, by examining this V.S. Rangadurai case, what we understood? Not filing two cases and despite received fees from the client and conveying false information to the client is professional misconduct. Come to another case that is called P.D. Khandekar versus Bar Council of Maharashtra. P.D. Khandekar versus Bar Council of Maharashtra. Here, what happened? The advocate, a false affidavit, drafted a false affidavit stating that their marriage had been solemnized in Pune on the same day, knowing that the marriage had not been performed. So, despite knowing that the marriage has not been performed, he drafted a false affidavit stating that marriage has been solemnized. So, gift or movable property by a lady to her granddaughter, the advocate advised that number one is drafted false affidavit. That is one mistake. Second mistake is wrong advice. What is that wrong advice? Instead of spending huge amount on stamp duty and registration charges, he will get the work done 45 rupees only. So, get the work done. So, get the work done for 45 rupees only. So, simply for that, what he has done, drew an affidavit. He drew an affidavit stating that the land has been gifted. So, negligence without moral delinquency did not constitute professional misconduct. In cases of professional misconduct, degree of proof is higher than civil proceedings, however, lesser than criminal prosecution. That is the ratio. So, a ratio has been held in Khandekar case. What is that? Degree of proof is higher than civil proceedings, lesser than criminal proceedings. Which is the ratio? And negligence without moral delinquency did not constitute professional misconduct. That is one case. Next, come to Harish Chandra Singh versus S.N. Tripathi case. It is 1997 case. Here, what happened? Property has been given in the name of his junior. So, in Mukhtarnama, advocate persuaded the client to sign Mukhtarnama in favor of his junior. That means property has been settled transferred to his junior. What happened then? The junior sold the land on the basis of the Mukhtarnama to the advocate's father. So, that is compliance property. So, compliance property came to the junior of the advocate first, then he sold it to the father of the advocate. Finally, it came to father's advocate's position. So, the conduct of the advocate was held to be gross professional misconduct. Harish Chandra Singh versus S.N. Tripathi, 1997. Next, come to S.T. Dalal versus State Bank of India case. An advocate in this case, State Bank of India engaged a firm to file a recovery suit. For that, original documents were handed over and payments were made towards fee and miscellaneous charges. But the suit which was filed has been returned by the registry with objections, but was never refiled, nor did the firm inform the SBI that the suit has been returned. So, the firm misappropriated the amounts paid by SBI. Supreme Court held it to be a case of professional misconduct and upheld the punishment for removal of the names of the advocate from the rolls. Next, John D'Souza versus Edward Ani, 1994 case. So here, original copy of the bill has been given to the advocates. When the testatrix had demanded a copy, what is the meaning of testatrix? Who executed? The advocate refused to hand over the original copy, so such conduct, professional misconduct. It is one. So, under A category, what is that under A category? Violating the confidence of the client. Under this category, we have seen 4 case laws. Next, come to violating duty towards the court. Violating the duty towards the court. There are some precedents under this category. Let us see what are the judgments. Kawal S.J. Chaudhary versus State Delhi Administration 1984 case. Here, regarding in a criminal case, an application was filed for modification of the bail order. What is the order in the bail? Criminal trial shall proceed on day-to-day basis. But the advocates of the petitioner not ready for day-to-day hearing. Then the Supreme Court held that it is a duty of every advocate who expects a brief to attend the trial on day-to-day basis. So, any failure to do so constitutes breach of professional duty of the advocate. So, this is the duty of the advocate towards the court. So, duty of the advocates towards court. So, attend the trial on day-to-day basis. Next, N.G. Dastana versus Srikanth Shivde 2001 case. This is regarding seeking adjournments. Two advocates repeatedly sought adjournment in a case on one pretext or the other. What happened? One occasion they filed an application stating that their throat, they are suffering from throat infection, could not speak. However, both the counsels, what happened? They were on the same day they were found arguing in another court. They were found arguing in another court. So what happened? It comes under misconduct held by Bar Council of India and State Bar Council. Such conduct constituted abuse of process of court and was therefore in the nature of misconduct. Further ratio is that whenever witnesses are summoned or at present in the court, it is a duty of the advocates to carry out the examination of the witness. If they are not available, they should make alternative arrangements. If the complaint is genuine and does not show any malified or attempt to harass, it is the duty of the Bar Council to refer the complaint to the disciplinary committee. So this is also, this is regarding adjournment. Adjournment must be a reason, good reason, sound reason. So these are the examples for the duty towards the court. Next, come to C. Acting without authority of the client. This is one of the misconduct. Acting without authority of the client. Here, Bairam Pistonji Gariwala versus Union Bank of India. What happened in this case? We will examine. Order 23 rules CPC provisions are being interpreted in this case. In writing and signed by parties had been inserted through an amendment. This provision would also include compromise signed by the council. However, it would be prudent prudent for counsel not to act on implied authority of their client unless warranted by exigency of. So that means what? Advocate should act on implied authority of their client. That means not to act on implied authority of their client. That means authority should be expressed. Not basing on any provision which is carrying implied authority. So, authority from the client to the counsel must be expressly. It should be expressly. The exemption is exigency of circumstances. In such exceptional, urgent circumstances, he can act. Next. Narayan Pandey versus Pannal Lal Pandey. In this case, what happened? Advocates concerned had filed forged and fabricated wakalatnams and signed compromises on behalf of parties. So, filed forged and fabricated wakalatnamas and signed compromises on behalf of the parties without any authorization. Such conduct was held to be gross. So, filing forged and fabricated wakalatnamas, signing compromises on behalf of the parties without any authorization is called professional misconduct. Suspended for 3 years. So, this is C. Next, interpretation of the phrase professional or other misconduct. We will discuss about this class in next video.